Welcome to Fasken's 16th Annual Global Mining Group Seminar Series. My name is Frank Mariage, and I am part of the Fasken Global Mining Group, and I'm also a partner in Fasken's Montreal office. Today's webinar, Sanctions and Tariffs, the financial and operational risks every mining executive must understand, is the 6th webinar in our series of 12 seminars this year. A link of Fasken's PDAC events can be found underneath the video window. As you view the info slide on the screen, I'd like to provide a land acknowledgement. First Nations, Inuit, and Métis have been present in Canada for thousands of years. These Indigenous peoples have a profound and ongoing attachment to this territory. At Fasken, we recognize that we have a role to play in the ongoing process of reconciliation between Indigenous and non-Indigenous communities here and elsewhere in Canada. We have embarked on the reconciliation journey by adopting a plan with the overall purpose of contributing meaningfully to reconciliation. I now turn it over to my colleague and partner, Andrew House, to introduce today's speakers. Andrew, over to you, and have a great conference.
Thanks, Frank, and thanks to everyone who's joining us today, both online and here in our webinar series. We're going to talk today about a topic that, frankly, if I can be honest, I have always found a bit frightening, a bit alarming. The purpose of what we're doing today is really to help you avoid, and by you, those who are listening, avoid some of the experiences that we have witnessed in transactions, in various forms of M&A, where people have come to the table late on a topic that is, I would argue, is a bit Byzantine, a bit frightening, and terribly impactful in the sense that even if you don't understand sanctions, they understand you, if I can put it that way. They can impact you. And we want to make sure that we walk away from today's session allowing people to spot the trouble before the trouble spots them, to have practical strategies for identifying sanctions and tariff risks, and being able to step away from those risks and mitigate them appropriately. Let me walk you through our panel of experts very briefly. First of all, my partner, Cliff Sosnow, who is chair of Fasken's International Trade and Investment Group. He's one of the most highly recognized trade and anti-bribery advisors in Canada and globally. He's ranked at the top of his field by Chambers Global, Chambers Canada, the Legal 500, and the Who's Who Legal for his work on sanctions, export controls, national security reviews, and complex cross-border trade issues. He has more than 3 decades of experience spanning government and private practice and advises companies, governments, and industry groups on high-stakes compliance. He is also, I'm proud to say, chair-elect of the ABA's International Law section. And thank you again, Clifford, not only for being here today, but for all the help that you provide in my practice on a daily basis. Secondly, Tobias Wellner is a senior analyst with Control Risk's Global Issues team in Berlin, specializing in geopolitics, sanctions, and the global business impacts of regional conflict and space security. Remind me to ask you more about that, Tobias. He manages Control Risk's Sanctions Country Monitor, which covers 224 jurisdictions and advises clients across sectors on how shifting geopolitical and regulatory environments affect their operations and strategy. Tobias brings deep experience from previous analytical and humanitarian roles across Africa, the Middle East, Europe, and the Americas, and is supported by academic training from King's College London, a great school, and the University of Applied Sciences at Bremen. Next, I'm very pleased to introduce Erik Woodhouse, partner in Crowell & Mooring's Washington, D.C. office and a leading advisor in the firm's International Trade and Financial Services Group. Erik brings deep experience in economic sanctions and anti-money laundering matters, shaped by his work both in private practice and senior roles at the U.S. State Department and Department of Treasury. Erik has guided global companies, financial institutions, and emerging digital asset firms through complex compliance challenges, high-stakes investigations, and has worked closely with Crowell's cross-disciplinary team of former regulators and prosecutors. Interestingly, before joining Crowell and Mooring, Erik served as Deputy Assistant Secretary of State for Counter-Threat Finance and Sanctions, where he helped shape U.S. sanctions policy around the world. We'll talk a lot about Erik's previous existence in government as we get into some of these sanctions issues. Also joining us today from Mexico, Florent Patoret is a partner at Galicia and has led significant international M&A transactions and advised global clients, especially French companies, on establishing their businesses in Mexico and managing ongoing corporate compliance. Before joining Galicia, he spent several years at Cleary Gottlieb's Paris office, specializing in M&A and capital markets, and he's admitted to practice in Mexico, Paris, and New York. Florent holds degrees from Université Paris 12, Université Paris Dauphine, and the New York University School of Law. He is widely recognized as a leading corporate and M&A specialist by publications such as Chambers Latin America, Chambers Global, and the Legal 500. So I hope I've convinced you of the expertise of our panelists. Again, let me say that I am not a sanctions expert. I rely on sanctions experts, and I'm delighted to have the people that you see on screen today to help me answer some of the questions that plague me when I am doing deal work. I work in foreign investment, which is to say Canada's security-oriented control of investment. I have repeatedly had the experience of discovering mid-transaction that sanctions, as important and impactful as they are, has been not fully contemplated by deal parties. And this is where people like Cliff Sosnow have come into the mix, sometimes later than he would prefer. And what he's asked me several times, and I'm now fully listening, is to say, Andrew, let's do this right. Let's do it from the beginning. And so our purpose today is to talk about how to approach sanctions correctly. Let me quickly shift into gear, starting with Erik. When you were at State Department, you helped make and execute sanctions policy. Can we just go to first principles, to the basics for a moment? I don't want to assume people understand everything they should understand about sanctions and their foundational concepts. What are sanctions? Why do we even have them? And how do governments use them? And by way of a preview of the follow-up, who or what do we sanction and why?
Thanks, Andrew. It's really a pleasure to be here today, and thanks to Cliff and Fasken and the organizers for putting this together. I'll touch on a few basic points to try to set the landscape for the rest of the discussion on sanctions. So first, what are sanctions? Sanctions are foreign policy tools that governments use to exert pressure on adversaries. The targets can be entire countries like Iran or North Korea, or they can be specific entities or individuals, essentially anywhere in the world. The restrictions imposed can vary from full embargoes on countries to a range of more targeted prohibitions that apply to those countries. Or if the targets are individuals or entities, these can range from blanket prohibitions on any sort of activity and full asset freezes to a range of various narrower prohibitions that apply to particular entities or individuals. These rules are typically set out in specific programs that address either countries or certain activity globally, such as U.S. counterterrorism sanctions or counter-narcotic sanctions. These programs are each different in terms of the policy context and objectives, the prohibitions involved, and any exceptions to those prohibitions. So it's important to monitor what rules apply in any given situation under any applicable program, and more than one program can apply to a given fact pattern. Now, to take another point that Andrew raised, what are sanctions used for? The most commonly cited objective of sanctions pressure is to change behavior, such as to pressure Iran to abandon its nuclear program. But as a secondary and often shorter term goal, sanctions are often used to disrupt activity, to make it harder for adversaries to pursue their goals, such as actions to disrupt terrorist financing or actions to deny Russia the inputs and the tools that it needs to sustain its war machine in Ukraine. And lastly, how do sanctions work? This is a complex topic, but I'll make a few basic points that I hope will help orient the audience. In the U.S., from the U.S. perspective, sanctions work by regulating the behavior of U.S. persons or any person within U.S. jurisdiction. That is, they prohibit persons within U.S. jurisdiction from engaging in specific activities with the targeted country or individual or entity. U.S. jurisdiction in this sense is very, very broad, and we'll go into more detail on this later. But because of the role that the U.S. plays in the international financial system and the global economy, the effect of these restrictions can and is felt all around the world. But that basic underlying mechanism of regulating activity within U.S. jurisdiction as it pertains to the targeted countries or individual targets is important to keep in mind as we think about the ways that sanctions operate in practice.
Thanks, Erik, very much. And I want to come back to that jurisdictional question and how far the United States in particular goes in extending or purporting to extend its jurisdiction globally. We all understand the big stick carried by the United States, but it is a fascinating topic to see just how far that reach really goes. And so we'll come back to that. But Clifford, I just wanted to turn to you for a moment. You were also a senior federal official, but here in Canada. In your view, how effective are sanctions, and what are some of the penalties for sanctions violations? Two very different questions. Are they working? What happens to you if you don't abide by them?
Right. Yeah, I was at the equivalent of the Office of the Legal Advisor of the Department of State. I would say, if they're intended to create regime change, and that's the standard, permit me for being very direct, they're not effective. If the sanctions are intended to reverse by themselves geopolitical decisions, like Russia's withdrawal from eastern Ukraine, they're not effective. This is partly due to sanctions leakage. Companies that are sanctioned can still do business with countries that are not sanctioning them, at least in theory. So Russia is still able to sell some of its oil. It's still able to purchase some supplies. And it does so from its geopolitical allies. What I would say, though, is that over time, the greater the number of significant economies that sanction a country, the greater the economic impact on that country. Even with that indirect leakage, the greater the potential for negotiating leverage in any diplomatic initiative to force compromise. This includes divesting nuclear weapons, think Iran, recognizing international boundaries or sovereignty claims, think Russia and Ukraine. But sanctions also are directed to individuals and criminal organizations like cartels. And I think at this stage, they can have a very significant impact. They deny the organization or individual banking services, access to funds, access to business ventures such as private equity participation, access to car or property insurance, access to corporate distributions, and finally, access to the sanctioning country itself. And this can be tremendously effective in hobbling the activities of that sanctioned person, as witnessed by sanctioned persons looking for any opportunity to have their names removed from sanctions lists, even if it means spending years in court to get a successful result. And on the other side of the coin, dealing with sanctioned countries or persons in violation of sanctions, Canada imposes criminal liability from anywhere from 5 to 10 years, depending upon the sanctions legislation, and fines in any amount at the discretion of the court. And this liability applies to companies in Canada, to their affiliates or branches operating in the third country, and to a Canadian citizen anywhere in the world, including those holding senior positions in a non-Canadian company operating or headquartered in another country. And it also includes directors, CEOs, and other officers. So its breadth is great, and its impact, as you mentioned earlier in the introduction, really is, when we're talking about criminal liability, very significant and impactful.
So, Cliff, you just used a term, sanctions leakage. I've heard of tax leakage. I think I understand what that means. What does sanctions leakage mean? And does that connect with a term that you've used with me a number of times, secondary sanctions? What is a secondary sanction, and does it prevent sanctions leakage?
So it's intended to prevent sanctions leakage. The sanctions leakage is the idea that a bunch of countries are sanctioning whatever, country A, Russia, Belarus, Iran, and the intention is to try to envelop that country with prohibitions and minimize their ability to do day-to-day activities. As Erik said, the impact is to have harm on supply chains, including investments. But if there's a back door that a sanctioned country can use, that blunts the ability to harm the supply chains of that particular sanctioned country. So, for example, Russia uses supplies from China, and Russia sells its oil through countries that do not have sanctions. Think of Iran, think of the United Arab Emirates, and it uses that cash to continue on with its war efforts. So that's the sanctions leakage impact. The connection to secondary sanctions, at least in Canada, and Erik may have some thoughts on how the US applies it, but Canada has now moved into the world of secondary sanctions. And it's an odd beast, because under the Canadian version, a non-Canadian company in a non-sanctioned country doing business with a Canadian sanctioned company runs the risk of being sanctioned by Canada, even if the non-Canadian company is legally entitled to do business with a Canadian sanctioned company. And if they're sanctioned, they're treated like any other sanctioned company. No person in Canada can deal with them. They can't provide them with banking services. They can't give them access to investment capital from Canada, and they cannot bid on any Canadian government procurements. And so remember, we were talking about the connection between Russia and China. Several Chinese companies have now been sanctioned under the secondary sanctions rules. And so what this means in practice is that for companies outside of Canada, they now need to screen for whether the companies they're doing business with are sanctioned, not just in their home jurisdiction, but also by Canada. And that becomes an important consideration for them if they have Canadian investors, they're participating in Canadian mining ventures, including those outside Canada, or they have any direct or indirect commercial contracts with these operations. So Canada is trying to stamp out that leakage through those secondary sanctions. And as I said, the US also is a great user of secondary sanctions. Erik may have some thoughts on that.
So I just want to make sure. Go ahead, Erik, please.
Just going to say, I think Cliff gave a great account, and secondary sanctions work similarly for the U.S. They're most often identified with the efforts to stop Iranian oil sales that ramped up in the 2010s in the lead up to the JCPOA. And I think that's a good example, because in that case, the explicit threat from the United States was, we will impose consequences on you. We will designate you and impose sanctions on you if you buy Iranian oil, even if it's legal in your country to buy Iranian oil. And the reason for it was that obviously Iran makes a lot of money by selling oil. And so as a way to increase the pressure and increase the effectiveness of the sanctions on Iran, the secondary sanctions sought to pressure everyone else to also stop buying Iranian oil, not just U.S. companies.
So I just want to make sure that that I've understood this and that our audience understands it. If you're a U.S. company, let's back up for a second. You've got an Iranian entity that sells Iranian oil. It is sanctioned. If a UAE company buys that oil and then resells to a U.S. company, a U.S. person, corporate or otherwise, is that an example of a secondary sanction problem?
It goes further than that. If the UAE company buys oil from Iran and then sells it to a Chinese buyer, you don't have to have any connection to the United States at all. That company in the UAE could be designated itself for engaging and under a variety of different authorities for engaging in that transaction. And there's a very important point, and I think Cliff started to touch on this on the Canadian side. In the US, although the term secondary sanctions is most often used in certain cases, like for Iran and to a certain extent now Russia, almost every sanctions authority, every sanctions designation brings with it secondary sanctions risk. And the reason is every time someone is designated around the world, a company, an entity, there is an associated authority to designate anyone who provides material support or assistance to that person. And so this is what Cliff was referring to when a non-US company operating completely outside the United States needs to pay attention to the question of whether it is engaging with a sanctioned entity, because by doing so, it could make itself vulnerable to being designated by the United States and facing sanctions itself. And so it is not something that is only limited to programs where there's a very well-identified campaign, such as the efforts to stem the flow of Iranian oil. It really comes along with almost every sanctions action that the United States imposes. And this filters back into the sort of due diligence that's needed for transactions to really understand the risks and implications of certain transactions. You need to be putting this element into your due diligence.
So for anyone paying attention, the mind begins to swirl with the cross-border possibilities and dangers. How do we track these types of sanctions regimes that are not only primary but secondary, and track not only across law but fact and human behavior? Tobias, I'm going to shamelessly turn to you and the service that I understand your company provides at Control Risk, which is this database of, I think it was 224 countries. Talk to me about how you track these things. And then I'm going to then bring you back into the intersect between sanctions and tariffs. But first of all, just talk to us about how you monitor this level of complexity globally.
Yeah, thanks, Andrew. To answer your question, I think we're taking a risk-based approach. So I work for a company called Control Risks, and that's exactly what we're trying to do to help with our clients. So we are not a law firm, such as just said, and we get asked and brought into the room for our clients when it's about understanding their risk exposure and what it means for the operations, for their business strategy, but also for their M&As and for their new project launch, you name it, really. We would come in and do a risk-based assessment. Now, how do we do this? And how do we do it in terms of our sanctions country monitor? We are taking a 30,000 feet overview and are considering the sanctions that are in place by the US, by the UK, by Canada, by the European Union, but also by Australia and Japan, and then have a methodology which then looks at what are the sort of the key driving forces by all these sanctioning actors to impose sanctions. So we've delivered sort of a 5-point risk rating from extreme to very low, right? And extreme risk means that you will need to have extremely good compliance processes and super hard due diligence processes if you still want to do transactions in extreme risk sanctioned countries. On the low aspect, of course, if you are dealing with a very low sanctions risk in a jurisdiction, it means that any kind of transaction usually is enough to do the very basic sort of sanctions compliance checks that most of the companies on this calls are probably very well versed in. But when we do our assessments, we don't always look at the numbers and looking at how many entities or individuals are sanctioned in Mexico, for example, where there's hundreds. We are looking at sort of the depth and the geopolitical drivers and triggers by the US and the European Union to really enforce these sanctions. And so we're taking a mixed approach between data and political risk analysis where geopolitics definitely plays an increasingly important role.
Tobias, thank you for that. We've met in advance of this panel and sort of talked about what it is we all do, but I think I'm now obtaining an even more clear picture of the importance of what it is you do in tracking these things globally. We are all experts within our jurisdictions. You are keeping an eye globally on how jurisdictions interact. Florent, can I turn to you for a moment? I'm going to deviate from our plan a little bit. I just want to ask you how when you encounter a new client and detect sanctions risk, what's the process you go through to sort of introduce the topic and begin to do the due diligence and explore with that client what it is they're facing, and deal with the complexity that we're hearing about? What's the practical nuts and bolts thing that you do with a new client?
Yeah, sure. This is a complex question because there is not a one-size-fits-all answer to that issue. Especially in the mining industry, we're talking about companies, global companies, Canadian investors investing in mining project in Mexico. So you have various points of contact, and you need to understand the operation. And since we are Mexican lawyers, we're focusing on how they work in Mexico. At the end of the day, from a Mexican law standpoint, Mexico is not a jurisdiction with a heavy set of laws in terms of sanctions. We actually need to take care of regulation from other countries. And we'll touch upon that a little bit later. But as everyone knows, when you onboard a client in Mexico, what you need to understand is its operation and what could be the point of contact with foreign terrorist organization here in Mexico. So the secret to this issue is understand how they work, understand what they need, and understand what is the exposure of the client here in Mexico, especially to foreign trade, to foreign terrorist organizations. That would be our main concern and our priority when we onboard client here.
So we're going to shift to our next subtopic here, and I was sharing with Florent just before we went live that I was in Mexico last week when some of the trouble broke out, and I do just want to bring us back to sort of that U.S. global interaction. And Erik, I'll come back to you for a moment. We'll talk here for a couple minutes about the fight against cartels and how that intersects with the sanctions and tariff regimes. Cartels have long been subject to sanctions under counter-narcotics sanctions programs, and it's been a striking priority of the Trump administration. Have sanctions risks associated with cartels changed as a result of the presence of Donald Trump and his priorities? And what do businesses need to know about this? And feel free to make reference to anything that transpired in Mexico. I want to come back to Florent in just a second for his perspective on how things unfolded last week.
Excellent, thank you. I think this is a really important topic, given the focus that the Trump administration has had on cartels. And I would make, I think, three basic points. One is the administration has been engaged in a whole of government effort against cartels involving tools by the State Department, multiple parts of the Treasury Department, both sanctions and anti-money laundering tools and investigations, a redirection of resources within the Department of Justice to investigate and prioritize investigations of cartel links. And even as we have seen, the use of the U.S. military in a variety of ways. So the risk that is driven by the level of priority that the U.S. government gives to this is extremely high. That's the first point. The second point is just within the sanctions context, this is a very good example of how important it is to understand the implications of different tools that can exist within the overall rubric of sanctions. As Andrew mentioned, cartels, a number of cartels have been designated for many years under counter-narcotics authorities. But one of the notable actions of the Trump administration has been to begin using counterterrorism authorities against cartels, and specifically designating a number of cartels as what are called foreign terrorist organizations. And this is a term of art in US law that has some very specific consequences. The first being that there is very specific criminal liability for anyone who knowingly provides or attempts to provide material support or resources to an FTO. This criminal liability comes with expanded extraterritorial jurisdiction. So this reaches further out and can have a greater impact on non-US persons and companies. Just to give one example, the jurisdictional provision would allow the assertion of jurisdiction against anyone who is later found within the United States, even if it was years after the alleged conduct. The second major difference is that it brings with it a civil remedy in the United States, a private right of action for persons who have been the victims of terrorism to sue for their injuries, including not only against the terrorist actors, but when it was done by an FTO, then this remedy extends to anyone who aids and abets by providing substantial assistance to that foreign terrorist organization and their terrorist activities. What this means is that companies that engage with terrorist organizations, even indirectly, can face not only government enforcement in the United States, but also private litigation. And so just to illustrate a bit what this can mean, one of the most well-known cases in this area involves a French cement company called Lafarge, which had a cement plant in Syria. And after the Arab Spring and the rise of ISIS, found that cement plant in ISIS-controlled territory and engaged in making protection payments to ISIS in order to continue running that cement plant. Lafarge ended up facing a $775 million criminal resolution with the U.S. Department of Justice. And they are still litigating the civil claims that grew out of that, and I expect they will be doing so for many years to come. So the exposure is very different when you're dealing with FTOs than when you're dealing with entities that are sanctioned under standard sanctions authorities. The risk was already high, but now it's quite different. And so I think given again, the first point that I made about the focus of the administration, I think this is appropriately high on the radar. The last point I would make is that there have been foreign terrorist organization designations for many years. Historically, they have largely been in places that are, to put it in sort of simple terms, far away from the United States. Yemen, Syria, elsewhere. Obviously, there's risks, and there's U.S. and other companies that are engaged in those areas, and they need to be careful. But the designation of multiple cartels that are embedded and operate within the Mexican economy, in an economy that is as interconnected with the U.S. economy as Mexico, is and I try not to use this word very much, but I do think it is unprecedented. I think it completely changes the type of due diligence that's appropriate when you're operating in areas where there may be cartel activity. So the risks are very, very different, and the reality of operating in Mexico is very, very different.
So I just want to come back to Florent, as I mentioned, about the reality of operating in Mexico. We're in the midst of or in the lead up to PDAC week. We're mining focused, we're critical minerals focused. Doing business in various jurisdictions just naturally brings with it the realities of those jurisdictions. You work in Canada, you deal with cold. Sadly and unfortunately, cartels have been an issue in Mexico. Florent, how do you advise clients who are highly legitimate, successful mining companies on the way up. They're investors. When they may be operating adjacent to a cartel or in a territory that is cartel controlled or influenced. These are gut-wrenching questions. People are trying to do legitimate business. They come up against the need to protect their assets and their people, and yet you have these very, very stringent laws, both in Mexico and, as we've heard, in the United States. How do you navigate those things on behalf of clients?
I need to be careful with the answer. I, of course, need to strike a right balance and not scare everyone. So, I mean, there's different ways to answer that, and I can try to gloss over certain details, or I can scare everyone off and say that no one should do business in Mexico. Look, the reality is, and this is what was mentioned before about how cartels work and how they are basically participating now in every layer of the Mexican economy. So that's the reality. The other reality is that Mexico is a mineral-rich country, and we cannot not think about exploiting this. So we need to face the reality, and there is basically how we see things and how we present it to clients is there's three aspects that are extremely relevant. The first one, and this is the most material one, is the extortion issue in Mexico. Unfortunately, mining projects are generally located in controlled area by narco traffickers, to put it that way. So that means that mining projects are often subject to extortion from those cartels, what we call in Mexico derecho de piso. So basically, it's the concept of saying, just give me money and I'll let you operate, which on its face could be considered a doing business cost in Mexico. The issue, and tying that to what was mentioned before, is that you now have cartels denominated foreign terrorist organizations. And very important to mention that under these rules, there is no statutory duress defense. That means that a Mexican project cannot use the defense of being under duress by the cartel, saying that if I do not pay the extortion to the cartel, they're going to attack my employees, and this is why I'm doing it. This defense would not work conceptually with these designation of cartels as foreign terrorist organizations. So this is the most immediate and pervasive threat to Mexican project in Mexico. In practice, and we've seen it with clients, especially in Guerrero, for instance, which is a gold-rich area, that they're basically hiring private militia in order to protect their employees and be in a position to avoid paying this kind of extortion to cartels. The second aspect is about supply chain. I mean, the extortion is a direct threat. The other aspect that Mexican projects needs to be careful of is who they are hiring to participate to the project. And here we're talking about subcontractors, we're talking about logistics providers, we're even talking about labor unions. In Mexico, employees are organized into labor unions, and it's not uncommon for labor unions to have ties to cartels in certain areas. And it becomes an issue of if you pay money for services to those actors, then you're basically financing terrorism under the definition of the US law. So here we're saying to our clients, first, you need to address this issue with enhanced vetting of your supplier. You need to diversify your supplier in order not to depend from one supplier if you need to terminate the relationship because you were aware that those suppliers were involved with cartels. So this aspect of supply chain is extremely relevant. The threat is less immediate than extortion, and we see that there are ways to deal with it. And the third one, it's not directly relating to mining operation, but we cannot avoid talking about it because we've seen it last year in Mexico, which is investigation by FinCEN in the United States. So these financial organization that's basically launching investigation on any actors in Mexico, for instance, because they are somewhat involved with cartels. And in 2025, FinCEN went after 3 financial institutions, Banco, Intercam, Vector, because it was identified that they've basically processed payment from cartels. And we're just talking about processing payments and having bank accounts, and we're not talking about huge amount of money. Long story short, those 3 entities no longer operate and exist in Mexico. The consequence of just announcing the investigation and prevent them from processing payment in the US just basically was a decision that terminated their business. They had to sell all the assets. Those businesses no longer exist. And I'm mentioning this because this actually happened. We know that the US has intention to use that threat to institutions that process payments. And we can easily see how this could translate to mining companies that pay monies to cartels in Mexico. And the only fact that a global company would have its bank account suspended in terms of processing payment in the US would basically have heavy consequences for this company and could put it to a stop as it did for financial institution last year. So even if this aspect is not something that's been applied to mining companies, this is a consequence that people should be aware of and an instrument that the US has used against Mexican companies just last year.
So thank you for answering with such delicacy a question that I'm now realizing was a bit loaded, and I thank you for your frankness. You're making me feel better about the level of complexity we face in Canada. This is really serious stuff that you face, and your proximity, our mutual proximity to the regime that Erik has spoken about, the regulatory regime. It makes life very complex for lawyers and practitioners. Can I come back to Tobias for a moment? We sort of glossed over something that we had promised our audience we would talk about, and that is the intersect and interplay between sanctions and tariffs. If you had asked me a month ago, I would have said these things are 2 totally separate areas of practice. You have sanctions and you have tariffs. Cliff Sosnow happens to know about them both, but they are different things. In preparing for this webinar, I've come to understand that there's a lot of overlap. Can you speak to us, Tobias, about the interplay between these 2 concepts and how that has made life more complex for our clients?
Sure. Yeah. Sorry, everyone, bringing a bit more complexities into that if you're not tired yet. Essentially, sanctions and tariffs are designed to achieve very different things, right? And Erik beautifully explained this in the beginning. Sanctions are traditionally responses by governments to perceived international law, for example. They operate as instruments of coercion, calibrated to sort of really influence government behavior on the other end. Now, on the other side of the spectrum, you have export and import controls as well as tariffs. And those are traditionally responses to trade imbalances and economic competition. And also, those different tools are also imposed by different agencies within governments, right? In the US, that's different agencies that are overseeing those tools. In many European jurisdictions, it's the same thing. Now, what is new and what makes it all a bit more complicated is that the US under the Trump administration is using tariffs very much and increasingly so as sanctions. So, for example, the US imposed tariffs on India for its ties to the Russian oil trade, or the US also threatened to impose tariffs on any country sort of importing Iranian oil or sending oil to Cuba, right? Whereas previously, we would have had the US sanctioning specific entities, coming back to the secondary sanctions here. But now, I think the threat of tariffs under the Trump administration has really changed. And that is because that threat to use tariffs suits Trump's negotiation tactic so much better, right? Also, I think that part of the Trump administration is a bit more critical about using sanctions as they form sort of a part of regulations. Regulatory pressure on U.S. companies is certainly something that the Trump administration is against. And I think, Andrew, another big point here is that, in practical terms, and over the last couple of years, we've certainly seen, especially the U.S., but also China, and I know we'll talk about China a little bit later on, are both using a mix of trade restriction tools, sanctions, tariffs, export restrictions as tools of geopolitical statecraft. And I think we'll get to it, but you'll see that same sort of fragmentation process also within only the sanctions environment that we're all operating on. And divergence certainly is a big topic of talk here that I think we really need to address. And I think with divergence, I mean divergence between transatlantic partners, right? Canada, European Union, but also the US. And while Europe, where I'm sitting, I'm based in Berlin, is really doubling down hard on sanctions and enforcement posture toward Russia, the US kind of is not. Under Trump, we've only saw sanctions against 2 Russian oil companies. We have not seen many more US sanctions against Russian circumvention networks in third countries. Instead, as I mentioned before, we did see the US seeing tariffs. And I think officially to encourage third countries to wean off from Russian oil, that was sort of the logic behind these tariffs. And even though it was interesting that we did not see the same tariff threats over Russian energy imports against Turkey or China, and both countries really big importers of Russian energy. And so these Russian-related tariff threats were used by the US as part of other ongoing issues. And in the case of India, that's certainly trade talks, right? Also, while we had Canada, the UK, the European Union, they've all lowered the G7 oil price mechanism. I don't want to go into details on that one, on Russian crude oil, but the US did not back this move. So we're really seeing divergence over Russian sanctions politics amongst G7 members. And it was quite telling when I looked at the G7 statements on the 4th anniversary of the Russian full invasion in Ukraine. And that did not mention sanctions once. And that was quite a big shift, I thought. In fact, it didn't even mention any negative words towards Russia at all. And maybe, and allow me just to wrap up here, but what does that all mean for sort of companies and mining businesses out there? The mix between sanctions, tariff, export controls, expect more complexities to come, to put it simply. Geopolitical competition will really intensify and ramp up And that will bring an increase of use of sanctions, tariffs, trade restrictions in general. We now have already seen evidence, of a growing designations, expect new sanctions programs that will emerge, and really the lines blurring between the use of the tool. And if countries mix sanctions and tariffs and export control, there will be much more room for regulatory divergence between markets that mining companies are operating in, which makes it much, much harder for companies to really comply with these rules. And probably not breaking news to all of you, but all of you mining colleagues out there, you're special, because mining obviously sits right in the center of geopolitical competition with a national security-driven focus here, right? So especially if you're handling critical minerals, which the US and the European Union is very, very keen on, and Canada as well, obviously, that means that really, mining companies will remain highly exposed to disruption deriving from sanctions, but also tariffs and export control measures.
So, Clifford, I'd like to take this to you now on a comparative perspective basis. But before I do, let me just put a simplified and probably oversimplified proposition to you. Would you agree with the proposition that a sanction is something that you do in an attempt to modify the behavior of entities and individuals, whereas a tariff is something you apply in order to attempt to modify the behavior of a state? Is that a moderately correct statement? And you are never shy about correcting me, and you don't need to be shy.
I would say it's moderately correct. Yeah, look, they both have the same impact. The tariff is ultimately, as the U.S. Supreme Court has said, as Canadian Supreme Court has said, it's a tax. Tax is intended to modify behavior, but it's modified behavior in the context of sanctions to move supply chains away from the sanctioned country. And so in the case of, for example, Russia, there's a 35% tariff on dealing with any product that originates from Russia. Nobody wants to pay that additional 35% tax, and they can get the same product from somebody else without paying that. But it's the same thing with sanctions. When you're sanctioning an individual, what the government and sanctions regulators are effectively saying is, do not deal with that company. Now, the impact is different. One is tax, one is criminal liability, but they're both directed to the same goal of moving individual behavior away from businesses, individuals, government agencies in a sanctioned country as a way of harming that sanctioned country. And so that's where the intersection of tariffs and sanctions plays out. Of course, you can have tariffs on any number of other countries that really are not sanctioned. Canada has high tariffs on steel and aluminum, for example, from China, but it has very, very limited sanctions against China. The purposes there, again, are to get China to change some of its government support programs, and doing so by making it very costly for Canadian companies to deal with them. If I could, but just really, really quickly, Andrew, go back to this issue of cartels for Canadians in the audience and those dealing with Canadian companies. Canada also has designated significant cartels operating in Mexico, Venezuela, but the kicker is also in Canada. And the designation in Canada for terrorist entities means that any form of direct or indirect benefit, including, as Florent has mentioned, extortion-related security payments, logistics fees, reliance on cartel-controlled subcontractors, tolls, that's going to constitute criminal liability in Canada. We're talking about incarceration of between 10 and 14 years for CEOs, senior officers. And when we're dealing with companies, fines in any amount at the discretion of the court. And then one last thing is, as with other jurisdictions that have sanctioned cartels, the designation raises Canadian extraterritorial anti-terrorism exposure. And that means that any support that benefits cartels in any way in any country outside of Canada will attract criminal liability under Canadian criminal law. So just wanted to put that in, and unless anybody thought that Canada wasn't dealing with cartels as well. Sorry, Andrew, I lost the thread of your question. Is it you want to talk about comparative perspectives?
I just wanted to hear you say that I was moderately correct, and I think I did hear that.
You did.
I'm happy with the outcome.
You did.
I just want to pick up the global perspective here. We've talked about the complexity of tariff and sanction regimes. We've talked about U.S. influence and what many would view as sort of an extreme extraterritorial application or relevancy of U.S. law. Tobias, we're seeing a growing resistance in the global South to Western sanctions. Essentially, countries saying, look, enough is enough. We're just trying to grow our economy as you in the West have grown your economies in the past. You need to get off our back. You need to stop interfering in our economic destiny. How is this blowback from non-Western countries being managed in your practice as you interact with clients? And what are people? How are people dealing with that resistance to Western sanctions?
Look, if we'd be in a classroom, I'd ask for a show of hands for whoever's heard of the International Day Against Unilateral Coercive Measures. Unfortunately, I can't see your hands, but basically that's part of my answer to your question, Andrew. For the first time last year, we marked that day on 4th of December, and it was a United Nations organized day. Speak out against Western sanctions, or rather any sanctions that have been imposed by governments outside of the UN Security Council. Why? Well, because the vast majority of governments in the UN voted for this in the UN General Assembly. And it's a small sort of symbolic victory, but one that really shows.
No, we may have lost Tobias.
Instruments of coercion. Sorry, I might have missed that. I was saying that they see this as illegitimate. They would see Western sanctions as illegitimate instruments of coercion. Russia, Iran, Cuba, Zimbabwe, other countries have long spoken out against sanctions, particularly by the US and by the European Union. And many other non-Western governments remain very cautious about openly confronting US or EU over their use of sanctions. But opposition against these sanctions is certainly a rallying point. Also, it makes amongst BRICS nations, for example. And I think in the coming years, looking ahead, many more governments are likely to expand their own trade restriction toolkits. Now, these will not always take the form of formal sanctions regime, but they will include sort of foreign direct investment screening mechanisms, export restrictions, licensing requirements, and other sort of industrial policies. And sort of as these toolkits mature, companies are really sort of going to operate in a much more retaliatory and politicized operating environment, where I guess commercial decisions can trigger political responses across a variety of jurisdictions. And I do think, Andrew, we have to talk about China here, because China, over the last several years, really developed and refined its measures to retaliate against Western sanctions, including its anti-foreign sanctions law, its unreliable entity list, just to name two of them. And rather than using sanctions sort of offensively, Beijing has chosen to deploy its own restrictive measures selectively, and while sort of relying more heavily on trade-related measures, as we've seen with export controls in the critical mineral sector, for example. And it does so because it wants to signal assertiveness to Western governance. This approach sort of enables China to impose costs and project resolve while carefully managing perceptions in the global south that it's avoiding sanctions as a tool in and of itself. How's an example look like? Well, just this week, we saw China editing 20 Japanese to its export control list. And Chinese companies are now banned from exporting dual-use items to these companies. China said that these companies in Japan are involved in enhancing Japan's military capabilities. And notably, actually, this listing also prohibits foreign companies transferring dual-use goods made in China to these companies. So it impacts you even if you're not based in China. It's kind of unclear at the moment how China will enforce this, but it's pretty clear what Beijing is trying to tell us all and global governments out there to understand is, do not mess with our position on Taiwan. And I think this addition of these Japanese companies is sort of a signal of what might more to come out there.
So I'd like to swing over to Erik for a moment. And Erik, I'm not going to ask you to explain America any more than I would want anyone to ask me to explain Canada. But we have you here. You've got this very significant background in the U.S. government and now in private practice. We've all watched with extreme interest both the imposition of tariffs under what's called the International Emergency Economic Powers Act. And then the striking down of those tariffs under that same act. Can I get you just to explain to us what's happened recently with the Supreme Court decision, President Trump's response there too with the imposition of 10% and then 15% tariffs globally, and just generally help us understand what might happen next in the U.S. vision for tariffs, and tariffs as such a central plank of President Trump's view of the U.S. economy as it interacts with other economies, chiefly from our perspective, Canada. I just give you the floor to try to unpack this if you can. No undue pressure.
If you can is well put. No, thank you, Andrew. And I'll just start with a brief proviso that I am not a tariff lawyer. I have a number of colleagues who are tariff lawyers, and they have been exceptionally busy this year, as you can imagine. But I have been following the decision and its implications closely. So I think as a way to sort of unpack this down to one level of specificity for a general audience, IEEPA is actually the statute in the United States that underlies most of our exercise of sanctions authorities. It is an emergency authorities act that requires the president to declare a national emergency and then use emergency powers to address that emergency. As you can imagine, it is a very flexible statute that allows the president to act very quickly when the situation demands it. And that's one of the advantages, for example, of sanctions as a tool. They can be deployed very quickly. It had never before President Trump, it had never been used to impose tariffs. There's a little more complicated history with the predecessor statute and President Nixon. We can save that for a longer tariff discussion. But IEEPA itself had not been used for tariffs. President Trump relied on this authority to announce a range of tariffs, including tariffs addressing a fentanyl crisis that he declared, and tariffs addressing the sustained balance of payments crisis that he declared. Those are the so-called reciprocal tariffs that he announced in April 2nd of 2025. After imposing those tariffs, they were then adjusted in a variety of ways over time. But the president and his administration used them as a launching pad to initiate negotiations with trading partners around the world to address a variety of other trade issues in the relationship. So fast forward to the decision, and basically what the Supreme Court said is IEEPA does not authorize you to impose tariffs. essentially full stop. There are some more complicated questions about refunds and what have you that will play out over time. But it was a fairly crisp decision. And in the aftermath, it is clear that those tariffs that only relied on IEEPA for their authority would have to be terminated. And it raises questions over whether people who paid those tariffs are entitled to refunds. And that litigation will play out over some time. Now, we have seen the administration act on the same day to terminate the tariffs that were imposed under IEEPA. Now, there's a question if the administration used the reciprocal tariffs as leverage and as grist for negotiating broader trade arrangements with other countries. What now happens to those agreements? On a technical level, the tariffs that only rely on IEEPA, even if they're now sort of in those agreements, I expect will have to be removed. But those agreements sort of have their own life now. And I think the counterparties, and I think you're starting to see this a bit in the news, the counterparties are beginning to ask, well, does the deal still make sense? Does it, given that the president couldn't impose these tariffs, does the deal that we reached still make sense? I don't believe any of the agreements has yet come into force. Some of them are for actual signed agreements now, but I don't believe even those have come into force. And so the counterparty countries will have some room now to slow down or not bring the agreements into force or simply slow down negotiations to try to account for now the current landscape. And the last piece of the puzzle, I think, is that the president made clear in responding to the Supreme Court opinion that he will use other authorities to seek to impose at least similar tariffs. The first announcement was that he would use something called Section 122 to impose 10% tariffs that I think he then said would turn to 15. We'll have to see where it all lands. Section 122 is a different authority. It authorizes tariffs for 150 days, and so it's a shorter term authority. So we'll have to see how the administration now uses the other different tools in its tariff toolbox in a way to, it seems they intend to continue pursuing the same objectives they had in using the IEEPA tariffs, but now they're going to have to put together something based on these more disparate authorities. And I'll just close by filling in that last point there. The president does have specific tariff authority under a number of different tariffs, a number of different statutes. Those all address different objectives and come with different procedural or substantive requirements. And so they're harder to use than IEEPA, which is a very flexible and fast-moving authority. And so that's why I say we'll have to see where the administration goes in terms of trying to continue using the tariff authority to similar effect while using these much different authorities in place of what it had been doing under IEEPA.
So from our other three panelists, I'd just like to get your sort of short reaction to what Erik has told us, to the fact of the Supreme Court ruling, and give us a sense of what types of questions you're getting from inbound inquiries. And Tobias, if I can start with you, what has this meant in terms of geopolitical implications as you sort of survey the landscape? Are people reacting to the SCC ruling immediately, or are they sort of saying, like, I'm just going to wait to see how this plays out? Because I can see people rationally reacting in either way, immediately demanding change or adopting a wait and see. Both of these perspectives probably have merit. What are you seeing?
Thanks. And thanks, Erik, for sort of putting out the lay of the land here. In terms of implication, I would point out three, and some of them, Erik, you touched on already. One, this ruling is a setback, certainly, for the administration's tariff strategy overall. And there's definitely the point that, Erik, you made already, but I really want to hammer that down, about the repayment to importers, right? So the administration opposes those repayments, and the timing of scope of reimbursement are really unclear. And that will have a huge impact on businesses, right, who will also have to take a reputational decision whether they want to go to court against the Trump administration, essentially. Number two, the ruling does not alter the US administration's broader trade policy, right? The US will continue to use tariffs and the various different authorities that Erik already pointed out and other coercive tools to reduce sort of bilateral trade deficit and protect domestic and bring back domestic manufacturing back to the US. Number three, the ruling increases uncertainty over US trade relations with the rest of the world. Most will unlikely to sort of react immediately, very much aware that the US retains significant sort of leverage and may pursue sort of alternative ways of tariff policies. However, of course, the ruling impacts trade talks, and I think India and the European Union have already paused trade negotiations and said, I want clarity from you in Washington. And they will certainly, take stock and see how that will impact. I saw that Indonesia, who just signed a deal with the US last week, it's not implemented yet, has said this deal stays as it is. This decision by the Supreme Court does not impact the deal. So I think we'll see a mixed bag. Lastly, I think the ruling will also impact China negotiations calculus ahead of trade talks during Trump's planned visit to China in April. And in terms of questions, Andrew, allow me, what does it mean for businesses out there is, I guess, the main going question we've been getting. Uncertainty is always my reply. Uncertainty over trade tariffs will persist in the coming months. Further tariff announcements are very likely as several sort of sector-specific investigations are ongoing. Two three two investigation into critical minerals in April last year. In October, the U.S. Commerce Department found, surprise, it's bad, and the U.S. has to do something about it because it's too reliant on its critical minerals. So Trump decided not to impose these tariffs on processed critical minerals. And so for now, instead of doing those tariffs, the U.S. will negotiate deals with other countries. And if that isn't successful by July this year, I think we can expect the US to take actions in the critical mineral space, in the processing space. We might see tariffs, we might see sort of minimum export prices, probably, depending on how these trade talks in China will go against anything that's coming from China. So I think uncertainty is unfortunately sort of the biggest implication here.
Clifford,
if I could just make a brief, the last point on tariffs, from a compliance standpoint, the back end of all this, it's easy to think about tariffs in these sort of policy terms and macroeconomic terms, but the back end in terms of compliance are obviously importers have to figure out how to follow the tariffs, which involves not only figuring out what tariff applies, what rate, how much do I have to pay, but also getting that right. And something that we've seen in the enforcement community here is we've already seen signs of this increase, and I expect to see more increase in customs enforcement and customs fraud cases that are sort of the back end enforcement aspect of this policy making and tariff setting that really sits in the headlines.
Thanks, Erik. Obvious complexity here. I hadn't fully or even begun to consider repayment or people wanting their money back for tariffs having been paid. Cliff, your quick reaction to the SEC ruling, followed by Florent. Oh, we've got you on mute, I think, Clifford.
Sorry, I sound more intelligent that way. What we're telling our clients are three things. One, if they themselves are what's called, technical term is non-resident importer, where they themselves are doing the importation into the U.S., they may be eligible for refunds and to consult U.S. counsel in that regard. But two, we're also telling clients, take a look at your contracts. because the reality is that, as Tobias said, there's enormous uncertainty. And as Erik mentioned, there's other tools that the president is looking at. And so issues like termination rights, issues like who is going to have to pay these additional tariffs or these additional surtaxes, and then issues like refunds. If a company that's exporting into the U.S. had to pay the tariffs and there's a refund, is there anything in the provisions of their contract that entitles them to get reimbursed for the tariffs that they've paid? And if not, they need to look at their contracts, because it's likely that in other forms and other manifestations, there's going to be this difficulty. The other, of course, is we're telling them to take a look at your supply chains and think about other diverse sources of supply. In some cases, that becomes almost impossible or difficult. For example, in the auto industry, or for the purchase of steel, there needs to be qualification periods. But nevertheless, what we are doing is telling them you're entering into a period of profound uncertainty. Because of this ruling, in some ways, we really don't know what the next steps are, whether there'll be any sector-specific sanctions, tariffs, rather in your particular area, client. And so we're telling them, start thinking about buffering, start thinking about looking at other sources of supply, in addition to your contractual protections.
And Florent.
Well, in order not to repeat, I would say, and have another tone, we would say to Mexican client, don't pop up the champagne just yet. I mean, the Supreme Court decision has some limited impacts to really what's painful to Mexican companies in terms of tariffs. The first one, and talking specifically to mining, is that, as mentioned by Tobias, the Section 232 tariffs on steel, aluminum, and semi-finished product, copper product, are still in full force and effect because they're not HIPAA tariffs. And those tariffs are the one that have caused a lot of pain to the Mexican companies when we're focusing on minerals, especially aluminum and steel. The other part of the equation is that at the end of the day, at least 60% of production in Mexico was covered by the USMCA exemption for tariffs. So at the end of the day, when we're not talking about mineral products specifically, but products in general, there was exemptions generally applying to products. That being said, and that goes back to the last point of Tobias, what really, really bothers Mexican companies and investment in Mexico in general is the lack of certainty. You don't know if you can basically invest in a greenfield in Mexico. You do not know if you can reshore in Mexico from China, because you do not know what will be the treatment in a couple of months of your production. And that basically resulted in a stop in the nearshoring movement that we were talking about in Mexico, that we will basically reshore production and supply chain in Mexico. This movement is not dead, but the tariff have definitely put it out to that. And the decision of the Supreme Court is not a game changer in this respect. What we see as really a game changer in this respect in the next couple of months is the renegotiation of USMCA. We hope that satisfactory negotiation for the US will result in a decrease in tariffs applied to the US main partners, Canada and Mexico. And we believe that, we hope that this is what will give the best certainty to economic actors and investors in Mexico. So yeah, unfortunately, it's a good decision overall, this decision of the Supreme Court, but from a Mexican standpoint, it hasn't been a game changer.
So in our final 15 minutes, what I'd like to do is this. I'd like to get from each of you the most common misconception that you're hearing from clients. Things where people come to you, they ask a question, and you say to yourself, that's just wrong. Like you're moving from an extremely faulty premise. So if you can cite for me the most common misconception, just one, and then also, where do you think things are going in the next 6 to 18 months? And feel free to take a pass on that question, because this is both territory we have covered to a certain extent, but also a mug's game. Who knows? But if you have a view on most common misconceptions and where things are going and how businesses can prepare in the next 6 to 18 months, that would be great. And at the same time, let me invite any audience member, if you have a question, put it into the chat. I'll see it and pick it up and be able to relay it to our panelists. So why don't we start, we'll go back to Erik on most common misconception that you see amongst clients and what you think people can do to prepare for what's coming in the next 6 months out to a year and a half.
Thanks, Andrew. And feel free to remind me on that second part if I forget after answering the first. So I think a common maybe misconception or thing that is not fully understood but is very, very important is the question of U.S. jurisdiction for sanctions and how it works. This has been referenced a couple of times already, and I think it's important to go into a little bit more detail. In basic terms, U.S. jurisdiction for sanctions purposes applies to U.S. citizens and permanent residents wherever they are in the world. It applies to U.S. established entities, again, wherever they are in the world, although it doesn't usually apply to foreign established subsidiaries. It sometimes does and sometimes does not. And it applies to any person physically in the United States when they're engaged in particular conduct that's relevant to sanctions. So even someone on vacation in the United States, if a company executive is here on vacation and does a phone call with his team back home, that activity is subject to U.S. jurisdiction. That's already quite broad, but it doesn't stop there. The question is not just Company A sells widgets to Company B. If Company A and Company B are both non-U.S. companies, you can't stop there. The question actually is, does any part of the activity contemplated by selling widgets from Company A to Company B touch U.S. jurisdiction? This could be because there are U.S. nationals working for either of those companies. It could be because the financial institutions involved in the payments are U.S. financial institutions. It can be because those companies rely on outsourced IT infrastructure or back office functions like accounting and human resources that are occurring in the United States. It could be because third-party service providers are American companies or otherwise subject to U.S. jurisdiction. It is really this question of, is any part of the activity, does it touch the United States or fall within U.S. jurisdiction? Because if it does, that can be a basis for OFAC and the Department of Justice to assert jurisdiction over persons, even non-U.S. persons, involved in the activity on the theory that a violation has been caused that is within U.S. jurisdiction. And that is where a lot of the reach of the direct enforcement comes from that can apply to companies really anywhere they are in the world. And so just to summarize from the perspective of a non-U.S. person, when it comes to U.S. sanctions, you need to pay attention first to the question of, is anything that I'm contemplating, or does any of this activity fall within U.S. jurisdiction as I've just described? That's number one. And that would tell you if you could be subject to direct enforcement risk in the United States. The second is there any designation risk here? We discussed earlier secondary sanctions and how almost every sanctions program has authorities that operate like secondary sanctions. Am I engaging with another sanctioned person in a way that could make me vulnerable to being designated? So first, it's the direct enforcement risk from falling within U.S. jurisdiction. And then second, even if you are not within U.S. jurisdiction, are you making yourself vulnerable to being designated by virtue of this activity? And the last is, as a result of 1 and 2, many non-U.S. persons around the world, particularly banks and companies that have a lot of engagement with the U.S., comply with U.S. sanctions rules, even when and to the extent that they're not required to. They voluntarily do so because it helps protect. It in many ways reduces their risk. It is difficult to manage these exposures, so it can reduce compliance costs just to say we're not going to do it. And it helps protect relationships. For example, banks, it helps them protect their correspondent relationships in the U.S. and what have you. And so even if you get through gates 1 and gate 2 and you're okay, you can still run into practical problems because counterparties are going to say, well, I'm not going to process that payment because I think there's a sanctions risk here that I'm not willing to take. So from the non-US perspective, there are really 3 gates you have to go through to fully understand what US sanctions can mean for a particular transaction. And then I'll do very, very short number 2, which is sanctions can apply to people even if they're not on a list. They apply to anyone generally owned 50% or more by any other sanctioned persons. And so you cannot just screen your counterparties. You actually have to do diligence on your counterparties to know about their ownership, to know if they are subject to U.S. sanctions. That really changes the game in terms of the nature of the diligence that is required. So if you're just screening, you're not answering all the questions you have to answer. To come back to the second part of Andrew's question, I think I would expect to see continued focus on cartels and activity around that, including enforcement activity. I think a major open question is when the U.S. Department of Justice will announce a major enforcement activity around material support to these terrorist designated cartels. I think we've seen already the way that the Trump administration is approaching sanctions. I mean, there's been a heavy emphasis on Iran. I expect that will continue, but we'll have to see where Iran goes in terms of the current military buildup and the talks that we hear are happening. But those actions have been sustained, and we'll have to see where Russia goes. We could spend a whole other conversation on the divergence issues that Tobias raised, which I think are also very important. We've seen different signals from the administration over the years. It has tried to engage on the question of the Russia-Ukraine conflict and trying to find a resolution. But there is certainly more capacity to do more on Russia from an economic pressure perspective. And I wouldn't assume that just because they have not done so yet, that they are not prepared to do so if the decision gets to that point. So I would still be watching the Russia space very, very closely. I could keep talking for a while, but there's a lot that we can cover. We'll never get to it. So I'll stop there, turn it over to my fellow panelists.
Really fascinating. And Clifford, I'm going to come to you on most common misconceptions, and then to Florent. We'll finish with Tobias on where are things going. So Cliff, to you first, most common misconceptions and what you do about them with your clients.
Well, one of the most common is that if a company is not listed, and others have mentioned this, then that's the end of the sanctions inquiry. Sanctions regulators, at least in Canada, make it crystal clear that's not sufficient. They really need you to look at the persons that stand behind the company. Unlike in the US, they'll look at not only ownership, they'll look at control, whether it's formal or informal. So if an individual has, let's say, for example, 25% or even 15% share ownership, nevertheless, there may be informal arrangements where effectively that individual is controlling the company. In Canada, that's sufficient enough to make the company that you're dealing with, even if it's not listed, effectively a sanctioned country, a company you simply cannot deal with them. Another is that if a person and their owners are not sanctioned, then no further sanctions concerns arise. Sanctions have multiplied, they've expanded, they've also increased their reach. In Canada, many now include prohibitions on providing services, goods, technology to a large number of industry sectors, including mining. So, for example, companies in Canada and their affiliates in other countries cannot provide any number of products or equipment or services if used in the mining industry in Russia or Belarus or any number of other sanctioned countries like Sudan or South Sudan. Even if the mining claim or the banks financing the transaction or the mining company and its shareholders are all not sanctioned. So you need to look past the actual individuals involved. You need to look at the services, goods, and technology being provided and whether or not those are also sanctioned. And the third, and frankly, there are just so many of them, but a third is that Canadian sanctions risk is low if dealing with a company in a non-sanctioned country, say the UAE or the Cayman Islands. As mentioned, Canada melts the barrier between companies and their ultimate owners. And Russian oligarchs, for example, are oligarchs because they are enormously wealthy with operations globally, including Canada. And because of that ownership, companies in Canada, their affiliates in the world, in Canada, Canadians anywhere in the world really cannot do any business with these companies. And in fact, Canadian sanctions regulators have said they now expect companies to do a risk assessment on any companies really that they're dealing with, some jurisdictions more riskier than others, even if they're not sanctioned, to determine whether to conduct this due diligence. After Tobias is commenting, I'll be interested to hear what he has to say about the direction, because I did have a few thoughts on where I think this is going as well from a Canadian sanctions perspective.
So we're very much at time, but I'd like to hear very quickly from Florent and last word to Tobias before we unfortunately have to close off.
Yeah. I mean, from a Latin American standpoint, and I'm talking about companies that are not necessarily in the US or Canada, but what we hear a lot is that compliance matter do not deserve budget to invest in. There's definitely this misconception that companies do not need to invest, and it ties to Erik's and Cliff's point that sanctions will not apply to them. So you need to fight a little bit on the necessity of investment that companies need to do. I think that one good thing that's coming of artificial intelligence is that now you can probably invest in softwares that can help you for your third-party due diligence. It's not perfect, but those are tools that probably could be looked at. But again, having thorough due diligence of your operation is something that we're fighting with a little bit with Latin American companies that believe that sanction would not apply to them. And just on a comment specific to Mexico on where we're going, one thing that needs to be looked at in Mexico is how the US is going to push Mexico to impose sanctions to China. There is that belief that Mexico is going to become China's other territory for its supply chain. So what we're expecting is that part of the USMCA renegotiation will basically come with a condition that Mexico should impose tariffs to China so that China do not send all its product to Mexico in order to be sent to the US.
And final word to Tobias.
Thanks. Just one really important outlook piece that we haven't discussed yet. Expect more EU sanctions enforcement activities. Look, it's been a game changer. Ukraine has really changed the narrative here in Europe completely about sanctions and sanctions enforcement. The EU has now adopted a directive, which basically means like breaching sanctions is a criminal law across all member states. That is being implemented. We are having all member states now building up their enforcement agencies. Everyone wants to have a new shiny enforcement agency office like in the US. So basically, I want to tell everyone here on the call, expect more to come from Europe. And even if only trade through the EU, so they're not based here, but only if you trade through it, if you rely on EU-based insurers, banks, logistic providers, or if you operate subsidiaries within the EU, you should expect that your European counterparties will really strengthen their sanctions compliance processes. And now, Andrew, I want to really end on like three things that I think I've really noticed my work and control risk. I've noticed how companies are managing all of this. So we're helping companies.
We may have a little delay for Tobias.
Exposure. Number one is understand your sanctions exposure, right? So where is your company currently exposed to breaching sanctions? If your company is exposed to tariff changes impacting costing plans, or where export controls might pose risk to supply chains, really make sure you understand and revisit your threat assessments. Number two, understand how your exposure might change, right? So we're doing a lot of work with companies looking at scenario work. Have you considered several scenarios which could trigger significant business disruptions to your companies? Where are the key triggers? How might they develop? And are you monitoring those triggers? That brings me to three and the last bit, managing risks. What is the risk appetite your company has? Has it changed? Who is managing sanctions risks or compliance risks, right? And how are these functions communicating with the broader company, especially to the C-suite? Do you have a good, trustworthy inflow of sanctions and trade restriction intelligence, right? Do you have a well-networked provider for, to carry out due diligence processes? And maybe let me finish by saying, looking back at all of this, the expanded use of sanctions, tariffs, and export controls really does not signal what everyone's been talking about, the end of globalization. Rather, I think it really marks a transition process towards a much more fragmented and flexible global system, and a system that's characterized by diversification and competing regulatory regimes. And in that system, advantage certainly will come to those companies that invest now into resilience and into being adaptable.
Just wanted to thank our speakers for their time and attention to this issue. There's so much to say, so much more we could say. We are unfortunately out of time, and so let me invite people to look for our speaker contacts on screen. Please do take advantage of that contact information. Questions arising, please direct those to the people you see on screen. Please fill out the survey that you see. There's a QR code that should also be appearing on screen. We'd love your feedback. For those who are legal practitioners in Ontario and Quebec, your CPD coding is also there on screen. And finally, let me shamelessly invite you to come back and be with us in person in Toronto or online on Monday, March 2nd at 8 a.m. for a seminar entitled Leading the Way or Falling Behind, Comparing Allied Critical Minerals Investment Control Regimes. I'll be back for that session and look forward to seeing you all there. Thanks again, and especially for your indulgence as we've gone over by several minutes.